Everybody, thank you for coming. You've obviously not yet heard enough about Leveson. There is an awful lot still to go, but actually I do think this is a really good evening to be looking at this, because we've had the report. Some of us were locked in that day and we're trying to assimilate it in an hour and a quarter before we went live at 1:30, which was a fairly interesting exercise. Then we've had all the political response from lots of the participants and so on. We've had the weekend to digest it. The debate is still going on. I don't know how many of you were watching the debate before BBC News Channel moved over to more interesting things and the Duchess of Cambridge's pregnancy, but thank you for coming anyway. What we're going to do is I'm going to ask you first of all, just for a marker which we will then compare at the end of the evening, how many of you, hands up, think that Leveson should be just brought into law or into practice as it is? How many of you really want Leveson to be where we take things? So hands up. That's 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18. And how many don't? Do you think that's pretty equal? And then how many don't know at this stage?
There's fewer in the second category.
Fewer in the second category, all right. Fewer in the second. And how many have actually spotted some of the flaws in Leveson, so think actually it would be nice to have most of Leveson, apart from the bits that allegedly would stop The Guardian having exposed phone hacking in the first place? This is something we will obviously debate. Or are you all happy that even with its warts, the people who actually voted for it think it's worth having anyway? Hands up again. Slightly more confused. There's a lot to debate, so we will take it from there. I think we ought to start, well, first of all, I'll introduce the panel, and then I'll tell you what we're going to do. Martin Moore is the director of the Media Standards Trust, a founder of the Hacked Off campaign, and they've been very much behind getting something done about this and very much in favour of statute. Rich Peppiatt over there is a writer, a broadcaster. He's a former journalist at the Daily Star, and his One Rogue Reporter show, which covers an awful lot of the more interesting elements of all this debate. Allegedly. Has just shown at the Soho Theatre, allegedly again. It started in Edinburgh where I saw it, but the word allegedly, he hopes, will get him out of an awful lot of trouble. I'm not convinced it will, but anyway. Next to me is Mick Hume, who is editor-at-large of the online magazine Spiked. He's author of There Is No Such Thing as a Free Press and We Need One More Than Ever. He takes a different line from those two. And finally, we've got Kirsty Hughes, who's the chief executive of Index on Censorship, which is an international freedom of expression, non-governmental organisation. And again, she has real reservations. And again, this is an event that's in association with Index on Censorship. So I thought, because Hacked Off played such a part in getting this all moving, I thought we ought to start with Martin. We'll then go to Mick for an alternative view, Rich, and finally Kirsty. If you've got questions that you want to raise at any stage, just draw our attention to it. We want it to be as free-flowing as possible, and if you've got points you want to make, I think we ought to try and bring them in. And we'll be going on till 8:30, unless we've run out of steam before then. So, Martin, take it away. What do you make of it? Are you really, really happy with Leveson?
I should start where I'm coming from. I mean, just a very brief anecdote about where we come from on this. We were a core participant, the Media Standards Trust, in the Leveson inquiry. We were a core participant because Gordon, a colleague of mine, and I wrote, with the help of a group of very good advisors, submission to the inquiry, as well as submitting a lot of evidence. And as core participants, we were allowed to the lock-in last Thursday to get early sight of the report. But what was great was we went in and they didn't know where to put us because they had two rooms for the lock-in. They had one room for the core participants from the media, and they had one room for the core participants who were the victims. And they didn't know where to put us because we were neither. At one point, they were thinking about putting us in the corridor, which probably would have been suitable, actually. But we ended up sitting with the victims. But one of the most telling things, I think, that I've read over the weekend, and there has been a lot written in the last few days about Leveson, was by Roy Greenslade. And I don't know the extent to which this is true or not, but he suggested that, as far as he knows, some of the media organisations in the core participant media room were asked only to send one word back to the newsroom, yes or no. And that was as to whether there was any use of any legislation to underpin the new system. And the reason why that has some credibility for me is because it seems as though some people have just pressed a button about the Leveson report and come out with the most astonishing barrage of attacks and smears and rubbishings and general misunderstandings of an awful lot of the report, and indeed what was actually said. I would add to that I don't think it's particularly helped by the fact that it is 4 volumes. I mean, this is volume 4, which is the smallest of the 4 volumes, and there are 3 others. So it is a very, very big report. And a disclaimer, I would freely say that I am still digesting it, and I have not been through every word of the 2,000 pages yet, and it'll take me a while. So I think an awful lot of the reactions have been extremely precipitous and extremely misleading. So just very, very briefly, this is just 3 things, 3 really rather important things, that Leveson does not recommend, even though you might get the impression that he did in his report. He does not recommend a compulsory system of independent regulation. He recommends a voluntary system of independent regulation, a voluntary system. Second, Leveson does not recommend a statutory backstop to independent regulation. He recommends a process by which an independent regulatory system set up and devised by the publishers themselves can verify and frank that system such that the public have confidence in it, and so that its members get some benefits within the law, particularly with regards to action taken against them in privacy and defamation. Thirdly, Leveson does not make Ofcom the statutory backstop, since there is no statutory backstop. He suggests that Ofcom could be the body that did that verification. This is one of the ones that I think has unfortunately led to an awful lot of confusion because of the other roles that Ofcom had, and I think there's been some entirely justified debate about whether or not that confusion actually is really rather material, and therefore Ofcom probably shouldn't be the body that does the verification. So, what does the legislation that he suggests, and this is the legislation as opposed to changes in criminal or civil law, which we can come to separately, so what is this supposed Leveson law that has been termed that? What would it actually do? Well, it would only do 3 things, and he's very, very specific about this. Number 1, the Leveson law would guarantee for the first time the freedom of the press from the government in law. Now, this is not, as it has been described by some, a First Amendment. We don't have a constitution, and this is not, as Mick will say as well, I'm sure, this is not a First Amendment. This is coming from the other direction. This is about legally constraining the government from interfering in the press, which would be the first time in law that has been written down. The second thing the law would do is to give authority to an independent body to verify the independence and effectiveness of a system put forward by the publishers themselves. So, as I say, a franking system, essentially. So the body takes a look at what they've come up with, whether it's Hunt, Black, or whatever, says, yes, this looks independent and effective, and it disappears for what he suggested for 2 years, and then for every 3 years after that, it just comes back and does another audit and says, is it working properly, is it functioning okay on behalf of the public? The third thing that the law would do, and it's only 3 things, the third thing the law would do was change aspects of the law to give benefits to those who participate in an independent and effective system. So, as I said before, it would give discounts, essentially, for those who are in the system, such that there is less chill wind from, because as we know, if someone takes libel action in the High Court, it is phenomenally expensive, and it is genuine, can have a genuine chilling effect on free speech and free publishing. So just on those, the first one, I think many within the press would rather like, the guaranteeing freedom and from interference from the government. The third one, in terms of what Black and Hunt called the arbitral arm, they proposed themselves. It was actually in both the proposals of Lord Black and Paul Dacre, that there should be some mechanism, very fast and very cheap, that helped publishers and ordinary claimants to get quick access to justice. So the only one that seems to have caused quite a lot of hysteria is this second one, which has caused an awful lot of wailing. So let's say you don't do the independent verification process. Let's say you just let the press get on with it and do it themselves. What would happen, or rather what is happening, because it's happening right now? Well, the leading figures within the biggest news organisations, the biggest nationals, particularly Lord Black and Paul Dacre, with the help of Lord Hunt, who have been very key in putting together the press's plan to date, will put together a new self-regulatory system of their own. What's wrong with this, you say? Well, this is the same Lord Hunt, Lord Black and Paul Dacre who put together a proposal that they gave to Lord Justice Leveson this summer that they claimed was entirely new, entirely effective and entirely independent, and which Leveson looked at and said did not come close to those criteria in his view. This is the same Lord Black and Paul Dacre who, with other many senior figures in the industry, ran the system of so-called independent self-regulation fronted by the PCC, which, and I recommend you read this chapter in the report, Leveson absolutely savages. He completely takes it apart. And of course, that's not to mention the 6 last chances to reform that the press has had since 1947, and each time failed. So the question is, if they are given free rein, if the press are told, go away and sort it out yourselves and we won't have any sort of independent verification or anything, how on earth can the public have any confidence that the system will be independent and effective this time? Do they just trust that it's 8th time lucky? And it's important to say, and I'll just end up on this point, but it's important to say that the public are pretty clear about what they want. We did a poll last week, which was caused a certain amount of discomfort amongst some newspapers. So rather than reference our poll, I thought it's worth referencing a poll that was commissioned, the only poll that has been commissioned since Leveson reported. And this was commissioned by the Sunday Times. And excerpts of the poll were published yesterday. So the Sunday Times commissioned a poll. What did it say? Well, it said that by 3 to 1, 68% to 21%, the public thinks that the press needs a much tougher, independent system of regulation with fines for newspapers that behave badly. That's 68% to 21%. 58% think that new laws should be passed by MPs to encourage newspapers to join this system of regulation. 26% oppose. There's another wonderful statistic, but I will leave it for a minute. So the point is that the public support Leveson. The victims certainly support Leveson. Certainly, it would appear over half and possibly even 2/3 of MPs support Leveson. But the Prime Minister doesn't support Leveson. The Prime Minister would rather reject Leveson or the central plank of Leveson. And this is what the public think of that. When asked, do you think David Cameron is opposing the new laws mainly because A, he believes in the principle of newspapers being free of any state regulation, 24%, versus he does not wish to jeopardize his relationship with newspaper owners and editors, 56%.
I think we can discuss the polls later because there are different polls that are giving different versions. I've got a specific question that I will come back to with Martin, but Mick, first of all, your view.
Thank you. Just talking about polls, I have no illusions that I'm in a very small minority on this issue. In writing about the whole discussion of the Leveson inquiry before the report, I was accused by Brian Cathcart of Packdoff of writing shameless anti-Leveson propaganda. So, and I'd just like to plead absolutely guilty to that. I am completely unashamed of being anti-Leveson, and I've always been a man who writes propaganda, which doesn't actually mean the same thing as lies, despite the popular misconception about that. I think anybody with a liberal bone in their bodies or any sense of history and the historic struggle for press freedom in this country should immediately react against the idea of any form of statutory underpinning, recognition, or whatever other kind of weasel words, as Paul Routledge called them, you want to use to describe basically state interference in the regulation of the press. You should react immediately against that, something which has been struggled against for more than 500 years. And it's quite shocking that something which was once the great cause of radical politics in this country, to free the press, that those who think of themselves as being on the left and liberal-minded have now become the most forceful advocates of some kind of statutory involvement in the regulation of the press. I find that a bit shocking. I also think that anybody with those instincts should have refused to endorse in the first place the very idea of a judge-led inquiry into the culture and ethics of what's supposed to be a free press, rather than queuing up to pay homage to Lord Justice Leveson and then complaining after he delivered what he was always likely to deliver in the first place. So I think that I'm very clear on the question of statutory involvement, but I think there's a danger of a slightly phony war where you have the whole discussion is, in the Cameron sense, are you for or against the statutory bit? And many people who are against the statutory bit are also endorsing everything else about Leveson. Like Cameron says, we endorse the Leveson principles, it's just the statutory bit we don't like. But I think the problems with the Leveson report go right through 2,000 pages of it, and there are many, many more problems of it than simply the statutory bit, which informs it, which means that the whole thing should basically be dumped as far as I'm concerned. I'll just mention a few of them because I don't want to go on too long. First of all, there's the illusion of independent self-regulation. I think anybody who's been to primary school ought to understand that there's an absolute contradiction in that statement. Independent self-regulation. If a regulator is independent of the press, it's not self-regulation. It's an independent. It is being independently regulated by a body. Now, independent of what? Independent of the press and independent of Parliament, independent of political parties. Fine. Are they to be angels summoned from the ether with a completely independent and impartial view of the press and all matters of liberty and news? Of course not. They are likely to be the same sort of members of the great and the good who advised Lord Leveson throughout his inquiry, very few of whom have much time for vulgar popular journalism or dirt-digging newspapers. And yet these are the kind of people who, in this independent body, will be put in charge of rewriting the journalist code and deciding what is and is not in the public interest, and also with their disciplinary arm of being able to fine newspapers for up to £1 million if they transgress the new rules as laid down by this independent body of the great and the good. And then you have which I agree with Martin, there's a confusion about it, but the role of Ofcom is definitely there, and Ofcom is a quango stuffed with political appointees, which is currently run by a former top advisor to Gordon Brown and Tony Blair. The illusion of independent self-regulation. Secondly, one of the major problems is we have a stick disguised as a carrot. We have this idea of voluntary incentive, voluntary participation and incentives to sign up. You will not have big court costs. You will have an arbitration process that's cheaper as a newspaper you can go into, and also you'll be able to get a kite mark. Like double glazing, be able to get a kite mark for good standard journalism if you're a member of this body. And this is presented as incentives and has been called carrots. As far as I'm concerned, if that's a carrot, it's a carrot shaped like a baseball bat with a 6-inch nail through the end of it. Because what's basically been said is, if you are not a member of this arbitration, if you don't sign up to this, and you don't become part of the new arbitration process, and you go to court, Leveson makes it clear you could be subject to exemplary damages. In other words, you can be made an example of if you're outside the system. And the kite mark, again, is a kind of form of ethical licensing as far as I'm... So that, I think, is a form of indirect taxation of the press. It's basically saying if you don't comply, you will pay financial penalties. That's an indirect taxation of the press, which has been proposed in 2012, exactly 300 years since 1712, when the Crown first imposed taxes on the newly unlicensed press in this country to try to stop the working class reading them and finding out what the authorities were up to. I think that's a very badly timed and in principle and practicality, a very bad idea. The kite mark is a kind of ethical licensing. What does a kite mark say? It says this is safe and child-friendly. So we're going to have a safe and child-friendly press with a kite mark. I would like to say that none of my heroes who went to the Tower and the gallows and prison to fight for press freedom in this country, none of them would have qualified for any kite mark of ethical journalism. They're all troublemaking, rule-breaking scoundrels. And I'm talking about John Wilkes in the 18th century or W.T. Stead in the 19th century. None of them would have qualified for this kind of kite mark. I certainly wouldn't want one, and they were all the better for it. That's that. I think it's the new arbitration process is basically, looks to me like a complainant's charter, where anybody, third parties or any representative group will be able to make a complaint, and as a consequence of that, the arbitration body will not only be able to find in their favour, but will be able to dictate where and when the apology or the correction is published. And we get into this whole kind of nightmare minefield of judges kind of, or judge-like figures in this arbitration body kind of guest editing newspapers and deciding what's going to be on the front page on any particular day. There is a danger of more state secrecy in these proposals. I think many people have observed that it's ludicrous. Leveson's idea, I won't go into it too far, I think it's generally accepted there's a big problem with it. Leveson's idea that there should be a ban on off-the-record briefing of police officers, which would be a big problem both for crime reporting and for the police as it happens, and it's likely to mean less information coming out of what the state and the police are up to rather than more. I think that's something we should look at. And finally, two other... there's also a danger of criminalising more aspects of investigative journalism with the way that Leveson proposes changes both to the data protection laws and the Police and Criminal Evidence Act, which would give journalists less protection of their material and their sources under the law, which I think is a very dangerous step. And then two final points. One is that Leveson seems to think that this new regulator should not only regulate a free press, but should also regulate democracy in this country. That he wants government ministers, shadow ministers, and political leaders to deliver accounts of all their meetings with newspaper proprietors, editors, and executives, as if it was actually this regulator's job somehow to regulate what our democratically elected leaders are up to and to hold them accountable. And call me old-fashioned, but I was under the illusion that that was actually the responsibility of voters in a democracy, rather than members of an unelected press regulatory body. And lastly, it comes to this point that Martin just talked about yes, the idea, Leveson's kind of big concession, which is we're going to have a law which will enshrine and make a government responsible for protecting press freedom for the first time ever. And isn't that great? Well, for me, this is a law basically to put the fox on a statutory basis in charge of the chicken coop. It is quite rightly certainly not the First Amendment. I'll tell you for one reason why it isn't. Leveson's third principle in this respect says that leaves open the idea of state interference with the media, quote, insofar as it is for a legitimate purpose and is necessary in a democratic society, as defined by whom. So it leaves open the door to political and state interference in that anyway, and there's no relationship to the First Amendment. I think if we want a statutory basis or background for regulating the press in this country, we would do much better to look to the First Amendment in America. You know, take Lord Leveson's 4-volume, 2,000-page, almost 1 million words and dump it in the dustbin of history, because I would rather have the 2 or 3 lines of the First Amendment of the American Constitution, which says that Congress shall not pass any law abridging the freedom of speech or the freedom of the press. And that is a law, by the way, a constitutional amendment which was inspired by the 17th century English Puritan revolutionaries. Puritans, who it seemed to me had much more of a sense of what a free press might mean than many apparently liberal-minded people in Britain do today.
Thank you very much, Mick. Richard, I'm not going to necessarily ask you to respond to him, but say what you want to say, because we will come back to all of those.
But I'll try not to, but
as much as you want.
I could be very quick and just say what Mick said, but the opposite, and I could probably have me pint and finish. But what I'm going to say is there's a reason. One thing you say, why are liberals and the left lining up to endorse Leveson? Why are they? Very good question, because people like Mick and people who may consider themselves left or centre, wherever they may come from the political spectrum, are trying to hark back to a time with a completely different social power structure, a time when you had a huge, powerful state, and you had a small, very press that was rebellious, that was trying to speak for the little man. But that's not the modern world. Our government is very much, our democracy, it's fairly weak compared to the corporate power that exists. That's the real power in our society, corporate power these days. The press is part of that corporate power. It is not looking in on that corporate power and holding it to account. It is more powerful. Rupert Murdoch is more powerful in many ways than David Cameron, you could argue. So the idea is that liberals and people on the left recognise this fact. They recognise the fact that the real power lies with the like of the Murdoch empire, and they would like to see some regulation. Why should they have an unaccountable power that they currently enjoy? Leveson is not a free speech or a free press issue. It has annoyed me for a long time now that even before Leveson was reported, we had this situation where it was the terms of reference were being reframed to make this between a free press and a shackled press, when it was never anything to do with that. Now, I'm all for free speech. I'm all for free speech, unlimited free speech. But there's a very big difference between my right to say what I believe and to impart what I want to say and speech as a business. The idea of corporate speech, speech which is there to make money. They got different things. There's a difference between me cooking at home and setting up a business where I cook and sell to the public. One, I can do whatever I want. I can cook with whatever ingredients I want. It doesn't matter. When I'm selling to the public, there has to be some sort of regulation. No one would argue with that. There needs to be some sort of rules. I think that's fairly common sense entirely. The other idea is that it's about a free press. We don't have a free press. I don't know where this notion that we have a free press has come from. I didn't certainly feel very free when I was working at the Daily Star or any other paper I've ever written for. No one said to me, here's a sit down, Rich, write whatever you fancy today and send it in to us and then you go in the pub, mate. I don't remember that. I don't remember that happening. No, I remember being told, sit down, write this in the way that we want it written, because this is our style, and what facts are inconvenient, leave them out. And if you don't do that, sod off home and don't come back tomorrow. That's not a free press. We have a press that is controlled by the corporate owners who are there to make money off of it. And so that is why, as a person of the left, I'm standing here and I'm backing Leveson. Thank you.
Thank you very much, Rich. And finally, Kirsty,
Okay, thank you very much. Well, I disagree with most of that. As a starting point, and of course a lot of the press aren't making much money, and perhaps I just start with that point because it's not come up so far, but it has come up in many of the discussions around Leveson, which is, well, what about the internet? What about the challenge that poses to traditional print media, and that we're all citizen journalists now, and we've got this 2,000 pages covering, as people have said, not only statutory underpinning, but all sorts of issues around press-politicians relations, press-police relations, standards complaints, public interest, and more. And you do have to unpack that and look at different dimensions of it. But I think we should, but the internet is barely touched on. And some people have said, well, this is going to be redundant before too long. And that may well be true. It may be redundant before too long. But I think where I would not go is to say it's therefore irrelevant now. And I'd say it's not irrelevant now for two reasons. Firstly, the press is still here today. The press has millions of readers. And the press has influence, for sure. It takes political stances. It writes editorials. It influences, to some extent, how people vote in general elections. And I think that's the nub of a lot of this discussion, and it's being lost in some of the yes, no to statutory. The press comments on and takes positions on our politicians and political parties. And I think the other main point in terms of the internet is that if you go ahead with statutory regulation, you are breaching, as Mick said, a very fundamental principle of press freedom. And that's Leveson's core proposal. So, of course, the debate shouldn't only be about that, but I think that is fundamental. And that will set a very unwelcome precedent for not only future regulation of the press, but potentially future regulation of the internet. So let's not think it doesn't matter because it's all going to be blown away by the internet. I think that's a bit too risky. So let me come straight away then to the statutory underpinning of an independent, my quotes, self-regulatory body. It seems to me that is a web of contradictions, and I think we need a very serious discussion of that. And to be honest, I was a little bit disappointed to hear Martin talk about hysteria and wailing, because this is a fundamental principle, and it's fine to to disagree over it, but let's not just label it as emotional, and let's not make it either an emotional lodestone. So let me just try and very briefly explain why, for me, it's highly problematic as someone who's defending and promoting freedom of expression. First of all, I think statutory underpinning is still statutory. It's still something MPs vote on. In that sense, it involves politicians in setting up a body to regulate the media. As David Cameron says, it crosses a Rubicon. And it seems to me that press freedom should involve, if nothing else, it's about the basic principles of politicians and the media having independence from each other. And let's just remind ourselves why. Why? Because governments and politicians and opposition, they care about their image in the press. They have spin doctors. They want to get a good image across. And why is that? Because we're talking about power, because they want voters to think nice things about them. They want voters to vote for them in elections. And that's why we don't want some of the cronyism that we saw and that was exposed partly in the Leveson inquiry and partly elsewhere. We don't want cronyism between journalists and politicians, or journalists and the police. But we don't want the sort of reverse cronyism that Leveson would imply if you give new power to politicians in having a say in what the characteristics of a press regulator are. You've got to have independent journalists who can hold politicians to account, along with the voters, who can challenge, who can criticise without fear or favour. And you've also, if you start opening the door to legislation, those laws can always be amended and developed later, not to mention the problem, and it's a very genuine one, and we come across this again and again in different laws, of the international demonstration effect in the Russias or Turkey or Iran, a whole load of, or Hungary's or Italy's, quoting what we do or what America does in different areas. So I think those are some of the fundamental principles, and I think it's very disappointing, some of people characterising this as this left-right split, as we've had people say, oh, Index on censorship is standing with the Mail and Murdoch. No, we're standing for press freedom, standing up for free speech. You don't always agree with the substance of what people say. You defend their right to say it. So for me, that's the core issue. And I think the issue around corporate power, I mean, Leveson says something quite interesting around plurality, and there's plenty of ways of looking at markets. And just like other laws, competition laws can apply across the board. Why are we talking about specific laws for the media? That's completely wrong. Let me say something just briefly on the voluntary issue. I think the Leveson proposal does follow the Irish proposal, the Irish system, quite closely. So it's a statutory voluntary system. So it's set up by a statute. It's then voluntary to join. But the characteristics of that regulator, according to Leveson, should follow 24 paragraphs where he sets out the characteristics that should meet, and presumably that should go into the statute, just as the characteristics of the Irish regulator go into a statute. Then, of course, he actually introduces Ofcom as the body that would say whether the regulator meets the characteristics, but that's a body that reports to government. And one voluntary catch-22, I would say, which hasn't come up, is that if you look at those 24 paragraphs, in paragraph 23, it says unless all the significant news providers join that body, it should not be certified, franked in Martin's word, as being a suitable regulator. So it's sort of voluntary, but unless everybody volunteers, you're going to say it doesn't exist, and then in his options but not recommendations, he starts talking about compulsory regulation with the Ofcom backstop. I think, as Mick says, it's not self-regulation if it's independent. I think we would argue for a mixture of independent and people from the industry on a regulator that could be set up with stronger powers and a standards arm. That's
we'll get on to what we should be doing.
Without statute. Yeah. It could be set up without statute. And my last point is simply, very briefly, because I think it's what Mick already said, on police press relations and politicians' press relations. No, you don't want cronyism, and no, you don't want corruption. But goodness me, how are we going to have decent investigative journalism? How are we going to get whistleblowing? How are we going to get an effective press if you've got everything monitored and recorded in terms of meetings? I think that's absolutely unacceptable. There are elements like the idea about an alternative dispute resolution process that Index actually proposed itself in our own evidence to Leveson that can work in a voluntary way, but I think the police, press, politicians, media is deeply
I think we'd all agree that the press, the politicians and the police got off lightly from Leveson. I'm not quite sure why that was, whether he thought volume 2, well, volume 5, 6, 7 or 8, but he's got a second inquiry that he's meant to be holding after the phone hacking.
4 years' time.
Well, when all of that happened. So who knows why that was. But certainly his main fire is on the press. And the issue now is really what happens next. We've heard the varying views about whether he's done a good job, whether he hasn't, whether it ought to be brought in its entirety. It has now become a political football, and the issue is how it moves forward. Because I think, and I don't know everybody on the panel agrees with this, certainly Mick doesn't, that what everybody is saying is whatever happens, the status quo is not going to remain, that there will be a tougher new body, it will have the power to fine, it will do things that it's meant to. The question...
I think there will be. I don't think there should be, but there
Yeah,
will
no,
be.
I know you, that exactly. All right, yes, I take your point. The question is how we get there, and I wanted to ask Martin. He doesn't like Lord Hunt. He doesn't like Lord Black's proposals, but both Lord Leveson and the government have said we want the press to set this thing up, whether it's supported by statute. However it's actually done, they want the press to set it up. Do you want the press to set it up? And if so, who do you want in the press? If you don't want Lord Hunt and you don't want Lord Black, what would you like to happen next?
Well, I mean, surely, I mean, this is where, in a way, Leveson called the press's bluff. I mean, he said they were all expecting him to say, okay, there should be an independent being, this is what we should do. And he didn't. I mean, he didn't in the sense that he said, no, actually, I think it's much better that you guys go back to the drawing board and you figure out, and he said he made very, very detailed criticisms of both the PCC and the Hunt-Black plan. He said, go back to the drawing board and come up with something that is genuinely independent and effective. And he gave a series of guidelines as to
look
what
like, where the chair of the board should come from, where the other members should come from.
Where the chair of the board shouldn't come from.
Exactly, where the chair of the board shouldn't come from. I mean, if you looked at...
Well, right, so he did set out details,
No, but the
didn't
point,
he?
the
He
point
didn't
was,
just say go away and invent it.
the point was that they had come, we've had this Leveson process, which has been such a, as many people know, a very laborious and exhausting process, at which the press were encouraged all the way through to come forward with some properly independent and effective suggestions for a new self-regulatory body. They came forward with very detailed recommendations. So that was, I mean, under enormous pressure. So that was basically, one must figure, the best that Black and Hunt and others could do.
So if they said,
So
we
he
accept your regulator, but we want it without statute, would that be good enough for you? And if not, why not?
Well, because the whole point is exactly as I said. We've been through this 7 times before. Every time, if you go back to 1949 to 1962 to 19...
But everybody agrees now that there will be something different. Or you do not accept that actually that will happen, that the £1 million fines, these various bodies,
No,
you don't think that's going to happen?
I can give you the report that I wrote a report about the Hunt-Black plan. And up until only a couple of weeks ago, the whole press was saying this is it, this is the new one, and I went through it, and it was astonishing. It was astonishing that the power that was given to, exactly like the Press Board of Finance before it, the independent funding body, which was supposed to be funding the organisation, to do appointments, to do...
I mean, Cameron is saying the industry should go away, see if they can do something very similar to Leveson, but without a statute. So that would be different from Hunt-Black.
There were two particular...
So what is the problem?
Okay, so there were
What does it say about an industry that's given the opportunity to go away and come back with proper independent proposals, but instead tried to put in a fast one?
That's not true.
That's
at all.
exactly what
I
they
think-
tried to do. They went, oh, maybe you won't notice if we just sort of mix it up a little bit, and we
Right,
still
so
mean that we've got the power.
Standards, arms, fines, and a civil contract.
No,
is the same as the
because you've
Press
still
Defence
got
Commission,
the
it's
press
not.
bot. You've still got a press bot-like structure where you have the chairman appointed by the industry, and that is not independent.
But this is last month's debate, and you're not answering the question.
You're missing my point. Is what does it say about an industry's ability to self-regulate
Kirsty,
if they cannot put forward serious
It's
proposals?
about trust and public confidence. I cannot see how, for an 8th time, the industry can come forward and say, honestly, this time we've really done it. Honestly, this time, there really is no role for the industry funding body when every previous time, including
But you're not answering my question. If they do what Cameron asks them to do and set it up without statute, what will be your problem with that?
Okay, number one, it's trust because 7 times is quite a number of times. Number two is on the basis of contract. He specifically says that there is an issue with contract. There is an issue with contract that at the most, Black was suggesting a contract lasting 5 years. And actually, if you speak to most lawyers, they say effectively you can buy yourself out pretty much any time in the course of that contract. So therefore, without some sort of way of incentivizing bodies to be within this body, and they recognise that, and what did the press come forward with? Instead of the press coming forward with some incentives that they similar to the Leveson incentives, which I think actually are pretty good, exactly like you. I think they offer some protection for news organisations and some protection for the public. No, what they came forward with was a suggestion to licensed journalists.
You keep slipping back to
they
the
came
last
forward with
month's
incentives.
Discussion, not the current discussion. If they accept the current incentives in a voluntary model.
So and again, who would you like to come, if it's not Lord Black...
Okay, so come to the point about the arbitral arm. So if they come forward with suggestions and they say these are absolutely Leveson perfect, and we come forward with a arbitral arm, who is going to have a look at that and say, yes, that will work, yes, the courts ought to take that into account? How will you do that without statute?
Well, you can do that, and that was actually part of our evidence to Leveson, was suggesting how you set up and options.
Just very briefly, what is the alternative to statute to make sure you've got this trust in it? Very briefly.
I think because it would still be a court-recognised process, so you could have it recognised by courts that if people go to this voluntary alternative arbitration system, that
how do the courts recognise it if it's not backed up in law? Because it's contracts.
It can be recognised in their rules of procedure.
Yeah. Mick, go.
I don't really agree with Ian Hislop about very much. I think he's kind of typically smug, kind of BBC, present company accepted voice. But I agree very much with his a lot of what he said at the Leveson inquiry. Hislop, of course, being the editor of Private Eye, a body that never signed up to the Press Complaints Commission. Like the Daily Express, although it gets talked about rather less than the Daily Express in that respect. And he said he didn't believe in a regulated press, believed in a free press, and he thought the press should be accountable, first of all, to the criminal law, and secondly, to the public, to its readers. And I think that's a pretty good starting place for this. He also said, by the way, that he suggested to Lord Justice Leveson in relation to being accountable to its readers that he hoped that Lord Justice Leveson would invite some News of the World readers to come to the inquiry and tell him why they had bought and enjoyed that newspaper in their millions. And I thought the shudder of horror that went around the legal and media elite at that suggestion spoke volumes about the character of that whole inquiry. The very idea that the public might turn up to a public inquiry and be consulted. So I think, opinion polls are one thing. The public's had no say in what might be in the public interest and never will have. And this is something about Hunt and Black. I think Hunt and Black is a disgrace. I certainly don't endorse that at all. I think it makes far too many. On one hand, it makes far too many concessions. Setting up a body by whatever contract, which would have more powers to police the press than the police currently enjoy in terms of getting information out of newspaper offices, fining them £1 million. Some of the things which Leveson's actually used in his report as well. Secondly, I agree completely. This idea that we don't want the state licensing journalists, but we'll have Paul Dacre licensing them instead. It's absolute absurdity. The idea that the market should be controlled only by these big players, and they will decide who gets a press card, basically. So you have a kind of industry license rather than a state license. Completely unacceptable idea of what journalism is or isn't. Fundamentally, the problem with it is, and this is where I really just differ with the whole discussion, is I think the whole discussion of the phone hacking. The post kind of phone hacking scandal and Leveson is based on a central myth which has been accepted by many people on all sides of the discussion, which is the idea, the myth in my mind, that the press has actually been too free to run wild in this country, and it needs to be tamed in some way, it needs to be curtailed in some way. I look at things the other way around. I think that the press in this country is by no means free or open enough, even before we have a new regulator of whatever sort appointed to come and wash the naughty newspapers' mouths out with soap. So I think that the Hunt Black thing has accepted the premise that the press needs to be tamed. And because of that, it's very difficult to argue against what Leveson is saying if you start from that position.
I mean, that's not an endorsement of phone hacking, presumably.
Well, I certainly don't endorse the hacking of Millie Dowler's phone or the cases that the News of the World have gone to court with. Like all other methods of investigative journalism, I think, I'd rule nothing out, rule nothing in. Everything has to be decided in a specific context. After all, David Lee of The Guardian, one of the great haters of the News of the World, went to the Leveson and said, by the way, I've hacked phones. But as he said...
It's because he thought he'd got a public interest out, and he didn't know he didn't.
As he said, I did it for ethical reasons in the public interest. That's ethics and public interest as defined by The Guardian, which these things always are. Editors and journalists make judgment calls about what reporting method is acceptable in any kind of circumstances. And I think, you can imagine any circumstances in which all kinds of underhand methods would be legitimate in order to get a story. None of the great stories of the last 200 years have ever been broken if everyone had obeyed the rules all the time, that's for certain. That's not to say that the hacking of Millie Dowler's phone is in any way defensible. The only person I've ever heard defend it is Paul McMullen, and I was on a round table with the News of the World reporter, and I was on a round table with him at the Independent last week.
Privacy is pedos is his soundbite, yes.
Yeah, and when I was on a round table with him at the Independent last week, even he seemed think that he might have got.
I mean, the other one people talk about is the MP's expenses. The Times wouldn't pay for the information because they thought it was illegal. The Telegraph decided that it was illegal, but they said there was a public interest. Again, it's suggested that Leveson might well outlaw that and make that...
Well, it's already outlawed by the Bribery Act of 2010.
Well, so, but yeah, you're then down to public interest. Martin, go on. Yeah.
Just a couple of things. I mean, I think we should debate this whole issue about it's illegal, it's the law, isn't it? Because it's one of the things that I would really recommend people do read is that Leveson does, and you can take issue with it or not, but he does specifically address this. So it's worth actually reading his sections on criminal and civil law to see what he says. And what he says is, there are two problems in criminal law. He says that the particular problem in criminal law of these types of crimes is that they are done in secret and they're often unknown to the victim. And the obvious case is phone hacking, and there are many other cases as well with the Data Protection Act and others. So therefore, the police never receive a complaint. So it's up to chance, and it was chance both in the case of Motorman and the Mulcair files, that they came across essentially a sort of, I think it was called a swag bag of evidence of huge systematic breaches.
They were very good note keepers. I mean, they were
great note keepers.
He actually says if they had not been so good at keeping their notes,
Glenn Mulcair, the private detective.
That's right. Yeah. So nobody would know that this had actually happened.
So that's the first thing. So he says, you cannot expect the police to do a big investigation with no complaint and no evidence. Half the purpose complaints brought towards it, as there was against the Sun back in 2003, rather than just see it as a single complaint, to say, is there evidence here of any more systemic and systematic abuse? The second reason he says in the criminal law...
Hang on.
Yeah. So on the second point he says about the police and the criminal law is that there is a real resourcing issue here, which is that quite rightly the police do prioritise, and particularly when it's a single as opposed to an enormous stack of allegations. If the police try and take action, for example, of breach of Section 55 of the Data Protection Act, they can be looking at 6 months to a year of trying to prosecute, at the end of which they'll end up with a £100 fine. So in terms of police resources, there's virtually no motivation for the police to pursue that. Just very quickly on the civil, because this is a particularly important example on the civil side, and it goes to the arbitration arm, which is that on the civil side, if you are wanting to take any civil action, in other words, if you're monstered by the press and you want to take any action in libel or privacy, that's not dealt with at a county court level or elsewhere. You have to go to the High Court if you want to take legal action. For most people, that is just unthinkably expensive. I mean, just absurd, and also time-consuming and exhausting and everything else. I mean, we're not talking thousands, we're talking tens of thousands, and if it goes to court, millions of pounds. Now, up until now, there have been people, including the Dowers, the Christopher Jeffries and the McCanns, who have benefited from what are called no-win, no-fees, which have been abused, but they've also helped some people without means. They are effectively disappearing as of April 1st next year. So, Lord Justice Leveson is saying, what happens to an individual like this if you don't have an effective regulatory system, if you don't have some way in which some ordinary person can get some redress? Is that fair? Is that what we want in our society?
I think just a few quick points here. First of all, the public interest defence to break the law and to carry out investigative journalism is obviously crucial, and it's very case specific. But you've got a completely uneven and inconsistent situation in British law at the moment, where there's public interest defences in some laws, but actually not in most laws. And that sort of gives you a completely uneven playing field. So that's one problem. Second problem, you've actually got, obviously, England as the world capital of libel tourism, but you've also got a fairly promising defamation reform bill going through Parliament at the moment, and one of the things Index has been lobbying for on that is to make it easier for smaller complainants or defendants on both sides to be able to get into these issues, to write a case criticising bad science or whatever it is without being tied up for 3 years in huge cases, and yet to also allow access. That's about making laws as we think they should be. It's not about saying that we need a regulator to go and stop a newspaper that's breaking laws by stalking or harassing or other allegations that need police powers to investigate and pursue and discover. So the idea that a regulator can police better than the police, I do find very confusing.
Let's open it up to the floor. Yes, we've got a question at the back. If you just indicate who's got a question. Yeah.
My name's Mandy Cormack. I want to ask a question, please, of information. We've talked around the whole issue of freedom of the press without actually acknowledging the fundamental change that has happened in the last 10 years, which is the formerly closed shop of distribution has been blown wide open by the web, so that anybody can actually get their voice out, their word out, their expressed views out. That has then focused the whole issue of real corporate power behind the news and the management of news in the UK and elsewhere. I wonder if we could please have some information that actually would demonstrate that some of these players are actually very, very wealthy, profitable players. They are not all hard done by, not all back against the wall, and therefore that I would be interested in the panelists' views on if you're saying that key players in this industry are wealthy, are making a great deal of money, why it is not that they should be regulated in a way that actually gives the people who are buying their products some sort of confidence in the integrity and the professionalism of the products that they're purporting to sell.
Anybody want to pick that up? I mean, are you suggesting that rich publishers should have a stricter code than poor publishers?
I'm just saying that if you've got a large industry, an international industry, you cannot actually just stand back and say that industry can set its own rules and behave as it likes. Well, we have not allowed that in the international financial industry. We've not allowed it in other aspects of our lives. We've allowed limited intervention by regulators or by law where it has been seen as appropriate. I'm trying to say that there is an international corporate business that is making a lot of money in this area. You cannot just stand back and say it's all about freedom of expression, because freedom of expression has now changed the dimension.
Yeah. Cool.
I think, Mandy, I do disagree with you, because I think freedom of the press is not the same as producing pharmaceutical drugs. So first of all, these big barons, press barons that you're talking about, the ones that are wealthy, you've got competition law, you've got criminal law, you've got libel law, so you've got a whole set of laws. You've also got, obviously, Universal Declaration of Human Rights, other human rights things that both establish freedom of expression and say in very specific, narrow, constrained ways, if there's a major national security risk you can't handle in any other way, you can also constrain freedom of expression. But the idea that you're going to target with a particular law the media industry, I actually don't see the argument for in the face of all those other laws.
What I would say is those with the biggest guns always want the least gun regulation. I mean, that's the fact of the matter. And yes, of course, you have these big corporate interests that want the least regulation because they've got the biggest megaphone. They can turn up to the loudest volume. who's looking, you know, we have in the papers, who's looking at Lord Rothmere's tax arrangements, talking about tax all the time? You're not going to read that in the Mail. You're not going to read about phone hacking, particularly in the Sun. Now, this is because certain people seem that they are protected because they are the head of media companies. That's not democratic. That's just, to me, that just doesn't make any sense. There are people who just seem protected from the same scrutiny as everyone else just because they happen to be very wealthy. And that seems to go against everything that's to do with free speech and democracy. And I'll give you one example that, to me, sums up what the issue is here. You have Professor David Nutt. Okay, now he came out with a science report in which he said ecstasy is safer than alcohol. That was just his report. That's what it said. And the Sun and the Mail went after his family, went after his children, because he used his freedom of speech to report scientific findings that didn't quite agree with what the Mail and the Sun believed. So they used the fact that they've got a massive megaphone to just try and destroy him. He lost his job. That to me is not about freedom of speech. That's about someone who's got a louder volume shouting down someone else. And I'm not going to stand up for that sort of freedom of speech. And it actually stops us as a society making any progress, because everyone's too scared. People in power, politicians, are too scared to discuss anything that's slightly radical, slightly outside the box, because they think they'll just get monstered by these newspapers that use their freedom of speech to try and enforce their own worldview on people. And I think as a society, it's holding us back.
And if Leveson is imposed in full, would that help things?
Well, one of the issues here, and this is a fallacy, is that this is all about breaking the law. I think actually one of the least issues is phone hacking was awful. But we've got a bigger problem. It's the stuff like the casual distortion and manipulation of fact that appears every single day in the papers. It isn't illegal, but you've got a lot of comment being melded in with news, and there is no declaration that we take a perspective. And there is no problem with having an angle. There isn't a problem with taking an angle. But the problem we have with our newspapers is they don't declare we're coming from this perspective. This isn't the whole story. This is the part of the story that suits our argument. And I think that's a real problem we have, because people still to this day think they're getting the news, i.e. the facts. And I think that really does, it perverts our social debate. And I think that that's a broader issue than criminality that is at this specific moment in time. I think as a society we have a real issue with that. And I think that that's something that Leveson hopefully will address.
Yes, we got some, here first, yeah.
I'm sure there's absolutely no disagreement here at all about the need to protect journalism from any kind of statutory control. Nobody would disagree with that. We're talking about what's on the table in front of us. Now, it would be a wonderful, ideal world. I entirely agree with Mick Hume that what we should have in Britain is just the First Amendment to the US Constitution, and with no kind of regulation of any kind. And that means, of course, that in the USA there is no regulation, not even self-regulation, of newspapers. The trouble is that we can't because of the world we live in. There are two main reasons. The first one is that the press has come under the ownership of these immensely powerful big corporate entities which have these incestuous relationships with power, the power that the press are supposed to scrutinise, the police and government. That Leveson was set up not just because of the phone hacking, but because of this stinking cesspit of corruption between the Murdoch press, particularly, and the others, and government and the police. And that's what the public mood is about. It's about there has never been such a public revelation of the workings of the British establishment as we've seen over the last year.
And yet Leveson
painful detail.
Gave them a virtually
For that reason, Leveson is valuable. But we can't just go back to the to a First Amendment position, partly because of who the owners are and what they do, but also because we've got the PCC. These powerful owners set up the PCC as a protection. It is a wall around them to protect them from the public. Everybody knows when people complain.
But they've said they're going to abolish the PCC.
No, I'm sorry, yeah, but it won't be any different. Nothing that is owned and that is paid for and set up by the newspaper industry can possibly be significantly different.
Leveson wants it paid for by the industry.
Yes, but I don't agree with him on that. But this is the answer to Kirsty's question. The answer is they can't. Why should they set up a body which is completely independent from them? And they can't ever agree to such a thing or set such a thing up because the owners won't let them. So actually, I'm sure they're trying really hard. And at least Leveson has set a set of standards. If we've got to have regulation, and I prefer that we didn't, unfortunately we're in a world where we are, that if we're to have regulation which is at all meaningful, and by the way, we should drop the word self-regulation, I agree about that. If we're going to have regulation which is independent regulation, which is at all meaningful, it has to have a tougher backup than anything the industry can possibly do. And unfortunately, that does mean the absolutely minimal structure that, I mean, it really is minimal. Well, it's not true, Kirsty, to say that it's going to set up under statute. It isn't. It's set up by the industry and recognised by statute.
Right, we'll get some more voices from the floor. John first, and then you, and then you. Yeah.
By the way, I don't think the founding fathers envisioned a Fox News and didn't think that they would claim First Amendment rights. They'd love to be re-regulating broadcasting in the United States. Mick Hume.
It's called freedom.
It's called freedom. I don't think it's the right to use the airwaves in a partisan way.
Sorry. You mean free speech is not the freedom to say what you think. You've got to say what you think.
A lot of people in the United States would love to have a broadcast-regulated environment that would stop a Fox News from destroying public discourse.
They'd like something as boring as the BBC, would they, as the alternative?
God bless the BBC. I work for Al Jazeera. It also has to pay attention to Ofcom regulation. I've seen more attention paid to trying to meet the standards of investigative journalism that actually...
Like Newsnight.
That's such a cheap... let's talk about let's talk about you and ITN if you want to talk about
All right,
claims.
come on then, let's talk about that.
All right, let me just put something to you. You're cavalier in your dismissal of the rights of minorities and third parties to try to get some remedy if they feel they're being bullied and systemically persecuted by a press, which has been done in this country. Some of us have seen up close individuals whose lives have been destroyed by a Daily Mail or an Express or a Daily Star. Why are you so dismissive of their rights to turn to an independent regulator to try to get redress in the same way people can through Ofcom? I'm a little surprised, too, that you, Kirsty Hughes, are not more concerned about the free expression rights of individuals who also have had no recourse because they cannot compete with the so-called corrections, that the only thing that they had at their disposal is to get a complaint heard, which we're not talking about complaints, we're talking about systemic biased coverage. And then I'd like to bring in Richard on that to put, real examples forward. That's my point to you, Mr. Hume and Chrissy.
I will let somebody come back, whichever of you want to come back on that first.
Well,
and he's the one who wasn't actually...
I wasn't referenced. You put it better than I did, John. But I think, Nick, because I think you do a great job, as you say, of putting the case for the rights of a free press, but the rights of the individual are forgotten. And certainly, when I read your book, which I enjoyed, I hardly saw some of the individuals, exactly the individuals that John is talking about, who, and let's not just talk about the Christopher Jeffries let's talk about, Rebecca Layton. Rebecca Layton, who was named by many papers as the saline serial killer, but she wasn't. She was arrested and she was in the cell for about 2 weeks. The police wanted to let her out. They couldn't because by that point, they were concerned that she was going to be lynched because the outcry and the trial by media had been such that everyone was convinced that she was. So they kept her in for another 4 weeks. When she left, she couldn't go back to her own home. She moved in, I think, with her mother or a boyfriend, and she'll never go back to nursing. There are Elaine Chase, a paediatrician who was wrongly accused of hastening the deaths of 18 terminally ill children, completely falsely again. Sylvia Henry, a social care worker who was wrongly accused of being negligent in the Baby P case and banned from dealing with babies in the future. I mean, these are people whose, as John says, whose lives have been completely turned over. And what are they supposed to do? If they have no access to justice, if they have no way of affording some sort of redress, what are they supposed to do?
I mean, of course those cases are awful, but I'm still very puzzled as to the idea that a regulator is somehow more effective than criminal and civil law. And notice that's what, and that is also, but can I just finish, because I think that's one point where Mick and I disagree, is that at Index we have argued for a tougher regulatory body, but one without statute, because that I disagree with the earlier questioner, it fundamentally breaches that principle of no government involvement. And I think, just two other quick points, we cannot have every newspaper or every broadcaster being like the BBC. Is that really what we want, that we have a press with no diversity of political views? I think we're part of a society at the moment. We've on the one hand got these breaches of laws and breaches of standards, but we've also got this huge growing intolerance of offensive speech. Look at the criminalisation of a lot of social media, criminalisation of someone who burns a poppy and puts a photo on Facebook. So we cannot create laws or regulators that put us all in a nice same space.
I think that's unfair to bring that in, because that is a completely separate thing. I mean, I'm completely with you. Ridiculous, but burning a poppy on Facebook, Twitter, police charge around, people are tweeting, because there's a fundamental difference between individual free speech and corporate free speech. And you're trying to, what has always happened throughout this argument.
The corporates, which isn't true.
They're working in a corporate structure. They're not there.
Published by News International to 10 million people. That's quite different.
It is. They're being paid.
Let's get some more voices.
Can I come back on this?
Yeah, absolutely. Yeah, you can.
Here's the thing, right? I'm a libertarian Marxist. I've been a Marxist all my adult life, and I've spent most of my political career founding, editing, and writing for independent left-wing publications. Right, that's what I've done. And I spent millions of words attacking the crimes of the British media, and its political prejudices, its racism, its discrimination, all of the things that it's been guilty of. I was at Wapping in 1986, done all those things, right? In this context today, my concern is that these people that you're talking about, the victims of press harassment of different sorts, are being used effectively as human shields in the pursuit of a quite different agenda of people who want to purge the press of things which are not to their taste. And so the question of press freedom becomes the central question today. And I'm afraid this distinction, which everyone's borrowed from Honora O'Neill and thinks is a brilliant work of philosophy, between individual free speech and corporate, is absolute nonsense. Freedom of expression is an indivisible right. It doesn't belong only to rich people, but it certainly doesn't belong to everybody except rich people. And what are you going to say? The Sun makes money and therefore it can't have freedom of expression. The Guardian loses money and so it can.
No.
Which is what most people in this room probably think. But listen.
The difference, can I come back on that?
Well, yes, of course, when I've finished. If I could just finish, you can say what you like.
Freedom of speech.
Freedom of expression is an indivisible right. And here is the thing about a free right. What is a free press? Here's the thing. Very difficult for us all to accept, right? And in the end, you're going to have to swallow it. What is a free press? The clue is in the question. It's free. It doesn't have to comply with what I think it ought to be. It doesn't have to comply with what John thinks it ought to be or anybody else here thinks it ought to be. Right? A free press, which we don't have in this country.
Is there responsibility in there somewhere?
Can I?
Yeah, you would hope so.
I really
yes,
want to get...
you would hope, John, that journalists are responsible and publications are responsible. But it is not for your idea of responsibility to be imposed on somebody, your taste and agenda to be imposed on somebody else.
Sorry.
Very briefly, because I do want to get some more voices from the floor.
Leveson specifically says that no regulator should be able to stop anyone from publishing anything. The only difference between someone blogging and tweeting and News Corporation publishing something, they shouldn't be restrained from publishing it. It's just if News Corporation does it and it publishes it to millions and millions of people, then going by the J.S. Mill harm principle, it can have a significantly greater harm than if a blogger or a tweeter does it and someone can respond. If they shout, and I'd love to hear your perspective on this, Kirsty, because if they say something which is blatantly untrue and call me a murderer or whatever else, what about my freedom of speech to be able to shout back and be heard and say, when they have the legal might, the financial clout and the audience to stop me from ever saying anything?
But libel laws already take account of the extent of publishing.
I've been called all those things in the press. That's life.
Does Sylvia Henry take advantage of the libel laws, particularly after next year when there are no win, no fees?
But when there will be,
we'll leave it there. Right, we're going.
I've been called an IRA bomber and a war criminal and everything else in the press. That's life.
Voices from the floor.
I think we all agree with the principle of a free press if it gives us a nirvana where, you know, the press hold government to account and stuff, but they don't. The owners of the press are in cahoots with the government, so you don't get what you want anyway. But secondly, the issue seems to be what's wrong with this body that's then going to oversee and Christie's got a problem with the regulator. But it's not the point that laws are pretty much reactive. They deal with punishing people after stuff has happened. Don't we want a regulator to try to get an environment where it doesn't happen in the first place and innocent people our lives are destroyed? So I just wonder, we've thought about the First Amendment from America. Perhaps there's something else we could borrow from America, which is, I think, a really good part of democracy, which is the Senate confirmation hearings. We talk about who would be on this independent body. Instead of having cronies appointed from the government of the day that you seem to think could then implement the politicians' wishes, have them okay, but that's the implication. Have them nominated, but then the members of this body would then go through confirmation hearings, and that's about the only way you get a middle way, because you're not going to have referendums or votes for the public to vote who'd be part of this body, because nobody's interested. But at least a Senate confirmation hearing, you know, might have some middle way of the people who would be in charge of the rules the press would have to abide by are actually sensible people who are going to stand up for the public interest. What's wrong with that?
Okay, we'll leave that point and we'll keep that hanging there. Did you have a point still? Yep.
Just very briefly, Kirsty, you said early on that freedom of the press is about basic principles, but surely Leveson came about because basic principles of journalism were completely thrown in the bin. And I'm with John Owen. I'm surprised that I haven't heard anything from you at all about the people who've been so badly abused by the press.
I'll come back to that. Did you still have a point? Yes, if we get the microphone over there. Anybody else who wants to contribute before we come back to the panellists?
Well, I think some distinctions should be drawn. Some of these problems are those of technology, as you said, with the hacking and the, particularly the phone hacking. It took the police a long time. I don't believe it should have taken the police a long time, and I think, I haven't read all the volumes, but obviously Leveson should have been harder on the police. But when it comes to those women you mentioned just now, Martin, several, and obviously the Christopher Jeffries case, as an American here, I've been amazed at the freedom the press has had to discuss matters which should be, I would think, sub judice. And you would think that the police arrested someone, there should be nothing more. They've arrested a male, 24, maybe they put out the name. And after that, until it gets to court, there shouldn't be very much in the papers. Does anyone agree with, isn't that the law in this land?
Well, one thing I'd say to that is, if the story gets big enough, all of that goes out the window. If a story's big enough, you can be whatever rules are supposed to be there, but you take the McCanns, you take the Dowlers, I mean, you get stories that are big enough and you just go sod it. And then one paper pushes the boundary and everyone fills up to fill the void behind it. And that's the issue.
The McCanns and the Dowlers were not, it didn't have to do with charging of an individual.
No, that's fair enough. That's fair enough.
But there is also another side. But if you shut down all coverage of cases, there's many other cases where it's actually led to solving crimes, to contributing information to the police. If you talk to the police, they'll say the media play an important role a lot of the time in that respect. So you can't throw the baby out with the bathwater.
Get a micro. I think the British. I think the British laws are tougher than. I don't think the Americans have sub judice in the same way. In the same way at all. It's far freer in the States to prejudice a trial, I think, than it is in the UK. The question is whether actually people are observing what the law is and whether the authorities are then prosecuting when they could do.
So I would love to see either Mick or you, Kirsty, at the centre of a media firestorm and the victim of this, and see if you would sit here and be quite as blasé about the right of the individual.
I'm not being blasé at all, and I wanted to come back to the two people who raised these issues around independence and the victims. I think I've been very consistent throughout in saying there are two things that can and should control the press. One is the law, all the laws, and getting the laws, criminal laws, defamation laws, other laws, right. But also, Index has said very clearly, and we argued for this back in July, we've not just said it in the face of the Leveson expose of all the bad to appalling practices. We've said you need a tougher, stronger regulatory body that will have a standards arm, that will include these alternative dispute resolution mechanisms. If you look at the phone hacking cases that we've heard about, there are enormously damaging intrusions into people's private lives, and there was no public interest defence in the Millie Dowler and all the other ones.
So would the new body do that?
See, and therefore you could do two things. You both apply the criminal law, which is being applied to those cases after all, and secondly you have a tougher body. But I think I think it was the gentleman in the middle was saying, well, how do you get the independent body to appoint the people if you're going a completely independent route? I think that is one challenge, but that, you know, because if you keep going arm's length, but you eventually get back to the government, I'd still have a problem with it.
Well, again, what if the person actually had a hard time in front of this committee? Who would then decide, actually, he's not performed or she has not performed well in front of this committee?
Sorry.
The hearing that he is suggesting, a Senate hearing. Who then decides?
But that's not my. I mean, my problem with statute is one of principle, and two, if you look at Leveson, he's not only saying how you set up an independent panel. He's describing in 24 paragraphs the characteristics of a press regulator, and that's what happens in Ireland as well. They're not to quite that degree of detail. So it's a huge step beyond just saying there should be an independent panel, and let's see how we get the right people on it. Because I think, and I assume that's what the industry will actually be looking at. How can we bring in some version of that without a statute?
Does anybody else like the idea of hearings, or think they're not that relevant?
Well, I think one of the things that was certainly for me, and I think for a lot of other people, really interesting about the Leveson inquiry, coming to the point over there, was actually that people were, for the first time, asked questions. Editors who normally never see the light of day were asked questions and had to respond and had to feel accountable. And you could see how uncomfortable some of them really were, sitting there having to justify stuff.
And proprietors as well.
And proprietors as well. Was it one of your ex-editors who had a very rough time in the stand? And actually, I think that's a really healthy thing. Actually, I think having that sort of thing where people have to explain what they're doing is a very healthy democratic thing.
Good. Question there or comment there?
Speaking as an investigative reporter for 3 decades, I think there's something quite key that we're missing here. If you take as your initial premise that democracy won't exist if you don't have healthy investigative journalism, which is a view I subscribe to, what do we know about investigative journalism? We know that at the moment it's on its knees, good public interest investigative journalism, because there's not enough resources. Right. So there's an irreconcilable paradox here, because on the back of the appalling behaviour within News of the World and other organisations, there's this huge backlash occurring, which is heading towards legislation. What will that do? That will crack down on and legalise the whole process of investigative journalism. Now, let me tell you, as an investigative journalist, you get there, you go down dirty and mean sometimes. You have to do things that are illegal. You have to make really difficult decisions. And if you have to argue every point with a lawyer, which is the ramification of all this, you won't be able to do it because no one will fund it. It's just as simple as that. So there's a real problem that the baby's going to get thrown out with the bathwater if we go to a much more statutory base where there's a lot more accountability, if there's data protection. Every journalist who's worth his salt abuses the Data Protection Act because that's how you operate. You know, there's endless things like that. If you're facing more and more regulation, it will just stop.
Can I pass the microphone here as well? And just have this one question, and then we'll come back to all of you. Just have a brief.
I just felt I had to come back to your question to Kirsty, where you said that if she'd ever been the victim of serious media harassment, she wouldn't be standing up and defending this. She may not have been, but at 10, I certainly have been doorstepped and harassed by journalists over something it wasn't. They wanted my parents, but when they got me, they decided they'd still ask me questions as a 10-year-old. And she's still making more sense to me than anyone else in the panel for the simple reason that what is immoral is very often not illegal, and there are good reasons for that. Adultery is the most obvious one. But the question of these stories are often about whether or not the harassment of an individual is in the public interest, and very often they're not. They're trivial stories about people's sex lives, or who they might know, who might have been famous. And the question that's still puzzling me is who has an obligation to report in the public interest in indeed this world where we're rural citizen journalists. I accept that the Daily Mail has a much louder microphone than the local news blog. But the local news blog, if it writes something that might actually be true, but rather an invasion of my privacy, may hurt me more because it's local, because all my friends read it. Why, still, the question remains, why are we regulating 10 particular newspapers and not everybody else?
Anybody want to answer that?
Can I come to both of those as quickly as I can? The first, I take your point, Paul, but I think we have to distinguish very carefully here between what Leveson has suggested in terms of regulation and any recommendations to do with the PACE, the Police and Criminal Evidence Act, the Data Protection Act, which are separate, and he deliberately separates them out. In terms of regulation, the statutory recognition that was talked about, I could refer you, Nick Davis wrote about this in The Guardian, where he was very specific. He specifically said that he thought there would be no part of the core of Leveson's report which would restrict him. Ben Emerson, a human rights lawyer who represented Associated Newspapers, he represented The Observer, he's represented quite a number of papers, said the plain fact is that Lord Justice Leveson's recommendations are no threat whatsoever to genuine investigative reporting. Now we can discuss, and we haven't got time here, we can discuss the details of PACE and the Data Protection Act and the issues around there, but that is separate. That is genuinely separate.
What about his police recommendations? I mean, some of the best stories I've ever had
okay.
Police officers, customs officers who told me stuff that they would now get fired for and won't tell me.
But hang on a second. Again, I think we have to be very careful here because Leveson does not, despite the reporting of it, he does not in any way ban off-the-record briefings. Leveson has a slightly bizarre section where he talks in a semantic way about changing the terminology of off-the-record briefings because he believes that there has been a misunderstanding that off-the-record is somehow concealed and secret. And actually, he thinks it's better to be clearer about that. He does not. Elizabeth Filkin, in her report, talked about recording meetings of senior officers. He does not make a recommendation around that. That was Elizabeth Filkin's recommendation separately.
Transparency and more recording of police and politicians' meetings, so I think it is a problem.
No. Wait, let's distinguish. Let's distinguish
and so on in
you
future.
get to a police officer, and the police officer in touch with, since Alistair Campbell, you can't get near him anymore unless you really have to put your hours in. And if you're already in trouble, it's going to come to a halt.
As I say, I have some issues with Elizabeth Filkin's report, actually. But we can talk about that separately. And I have some particular issues around what the police are doing and the way in which they're restricting it. But in terms of, if we come back to Leveson's core recommendation around regulation, that doesn't touch on that at all. To come to the point about this other point here, one of the things that no one's mentioned, and it was again one of the in the voluminous report slightly missed, is that he specifically said, you're right, he does say, to the points that have been made before, that the powerful, the big news organisations have to be in the tent because they have to take some sort of responsibility and accountability for what they publish. But he says that the system should allow for more than one approved regulator. So should a bunch of other publishers decide to get together because they want to take advantage of the benefits.
I think that's taking us into a whole new area.
All I mean is that it's not
one regulator that we can sort out. I think we might be able to do that. I think more regulators is probably...
Just a brief different response to you. I think probably we don't agree on all of what you're applying, but the laws of the land do still apply, actually, to the web. What we're actually expecting any day or week now is new guidelines, interim guidelines on social media prosecutions, because as I was indicating earlier, there's cases where this has clearly gone in quite the wrong direction. How many people in this room agree that someone who puts a photo on Facebook of poppy burning should get prosecuted? So we need guidelines around existing law and social media, but otherwise, can you really envisage a regulator that's going to sort of somehow deal with all individual bloggers? No, but I think a lot of this comes back then to editorial guidelines. Communities or individual bloggers groups of people who discuss together have their own ways of sorting out their own communities and sorting out their settings. I'm not saying it's perfect. This is you know.
We're coming to the end, so I'll go to Rich, and then
I think your question opens up another bigger.
We'll finish with Mick. Yep.
I suppose two points. One of the arguments that keeps coming up is the idea, well, millions of people buy tabloids every day, and so they can't all be wrong. Which is, to me, is an argument which keeps being referred back to. It doesn't really hold any weight. I mean, you know, just because someone buys a newspaper doesn't mean they agree with everything in it. I went to Burger King before I came here, and you know, if you took me down to the abattoir, I'd probably become a vegan tomorrow. You know, if you're going to see behind the scene, I think a lot of people who do buy tabloids would probably not. I don't think that, you know, if we had public hangings, you get a crowd. It doesn't make it right. And on top of that, the idea that we have a responsibility to the rest of the world to set a standard for free speech, and other countries are watching on and want to try and destroy free speech in their country with us as an excuse. Well, that is tosh, because we just are trying to sell billions of pounds worth of arms to Saudi Arabia. So if we cared that much about free speech, we would not be selling all of our guns and our aeroplanes to countries which we know repress free speech with those very weapons. So that is rubbish. And yes, that's what I'd like to say.
Thank you, Rich. And Mick. Yeah.
I don't want to talk about the details of different proposals regulating the press, but just to come back to a first principle, no one could deny that you could write a list, as long as anybody's arm in this room, of all the problems with the British press and the British media. Huge problems with the British press and the British media. I have been in the middle of various media shitstorms that happens, from 1984 when I was accused on the front page of one tabloid of being involved in the Brighton bombing, to very recently in The Guardian when I was accused of being the person in Britain most responsible for war crimes and their apologising for them. So, you know, I know all about all that stuff. I've also been on the other end of being sued for libel and left bankrupt and had my magazine closed. So none of those things alter my view of the first principle at stake here, which is that the point is any media outlet, any newspaper is capable of getting carried away in its crusades. News of the World, Newsnight, they've both done it on public record in their different ways. But the abuse of press freedom by some should not be turned into an excuse for the encroachment on that freedom for all, particularly by the authorities. Freedom is a messy business, and freedom of expression is an indivisible right. You can't abolish slavery, but only for white people. It's an indivisible liberty, and you either have freedom for all or for none at all. And we're getting into a very dangerous situation now where everybody says, I support press freedom, and the buts are getting bigger. And we need to go back to the principle of defending press freedom with no buts as the founding bedrock liberty of a civilised society. And all this stuff about Rupert Murdoch, Murdoch's influence over politics has been a big problem. You know, anybody on the left like me knows that of old. But I tell you, the other problem is Murdoch phobia. It's this idea that Rupert Murdoch is somehow to blame for everything that's gone wrong for the left and liberals in the world and in this country. The idea that Rupert Murdoch is a puppet master of British politics, to me, what do puppet masters do? They manipulate lumps of wood. And what that means is you're saying the electorate are a bunch of wooden-headed idiots who do whatever the Sun or the Star tell them to do. Anti-tabloid prejudice is always underpinned by fear and loathing of the kind of people that read and enjoy those newspapers. And that has always been the case historically, and that's something that I think we should guard against. The last point is about the web that somebody mentioned over here. There's a real opportunity, right? Exactly, the monopoly of the marketplace has been such a big problem. When I was editor of Living Marxism magazine, you know, you'd have to try and throttle somebody to get 3 copies of it into W.H. Smith on Euston Station. You just couldn't get into the marketplace at all. Now I've got a website, I'm the editor-at-large of Spiked Online. We have more readers in America than we do in Britain. Right? You can speak to the world. There's an opportunity to put some resources into building a new media. And I think those of us who want a different kind of media would be much better off putting our energies into trying to create that before it gets frozen and closed down, rather than banging on about Rupert Murdoch or asking Lord Justice Leveson if he would please put the world to rights for us.
On that note, it's been a fascinating evening. It's been really passionate, total opposite views on all sides. And I'd like to thank you for coming. Thank you for contributing. But please do thank your panel.